Well, hello and welcome back to my channel. How are you? My name is Joanne. I am a law student from Melbourne, Australia. I hope you're doing well. I wanted to tap down and have a look at this Tickle versus Giggle for Girls case. This is a case that went through the Human Rights Commission, and yesterday a decision was made that Tickle was indirectly discriminated against. Um, because of gender. So this is the summary judgment. So what the judge did was he did a very short summary, which summed that up because the actual judgment is something like it is multiple pages. And in fact, it was so long that when I was reading it yesterday, I couldn't actually read the whole decision because it didn't load properly. It stopped at one part of it. So it has now been done. So I that look, Tickle didn't get all her own way because one of the things that she wanted was the app to be reinstated, and that hasn't happened. But let's read the short version, and then we'll pull out the big version. There is a couple of very interesting things in here um, that I found to be very interesting because when we get into compensation, because it did state, I read it in here, maybe it's in the big one. Um, that she left the app because she found it boring. And so, because she left the app, she couldn't um, then, because she left the app of her own free will because she found it boring and people didn't engage with her. She wasn't, she couldn't get compensation because she'd already left. Anyway, we'll have a look at that when we get there. So, this is the summary. So, Federal Court of Australia, Tickle versus Giggle for Girls. In accordance with the practice of the Federal Court in some public interest importance or complexity, the following summary has been prepared to accompany the orders that I will make today. The summary is intended to assist in understanding the outcome of this proceeding and is not a complete statement of the conclusions reached by the court. The only authoritative statement of the court's reasons is contained in the published reasons for judgment, which will be made available on the internet at the Federal Court together with this summary. The short summary is intended to assist in understanding the issues and conclusions I have reached in a lengthy judgment. After this summary has been read, I will make my orders and publish my reasons. After that, the judgment and the summary will be available on the court's public file to anyone who wishes to read them, in addition to being placed on the court's website. So this is what the judge essentially read. Okay. The applicant, Roxanne Tickle, sued the respondents, Giggle for Girls Proprietary Limited, and Sally Grover, Giggle's Chief Executive Officer and founder, alleging unlawful gender identity discrimination contrary to Section 22 of the Sex Discrimination Act 1984. It is not in dispute that Roxanne Tickle was prevented by respondents from using a mobile phone social media application known as the Giggle app, marked for communication between women, which did not allow men to join or use the app. The issue is whether that was unlawful discrimination. The term cisgender refers to a person whose gender corresponds to the sex registered for them at birth. That is to be contrasted with a person whose gender does not correspond with their sex as registered at birth, commonly referred to transgender. The respondents do not accept the legitimacy of the terms cisgender or transgender. I find both terms useful and convenient for the purposes of deciding and discussing the relevant facts and in accordance with the gender identity discrimination provisions of the SDA, which is the Sexual Discrimination Act. So SDA, whenever you see SDA now, it's going to be the Sexual Discrimination Act. So quite often you write it out in full the first time, and then everything's abbreviated. So you'll just see Tickle or Giggle, and there'll be abbreviated stuff now. Roxanne Tickle is a transgender woman whose female sex is recognised by an official updated birth certificate. For that reason, I refer to her as Miss Tickle. The respondents operated the Giggle app during the period from February 2020 and August 2022. Ms. Tickle alleges the respondents' actions in removing her from the Giggle app constituted direct gender identity discrimination, or, in the alternative, indirect gender identity discrimination as defined in Section 5B of the SDA. Both forms of discrimination are unlawful in various contexts under the SDA, including work, education, provisions of goods, services, and facilities, and so on. This case is only concerned with the discrimination in relation of the provision of services via the Giggle app, contrary to Section 22 of the SDA. Direct gender identity discrimination is discrimination by reason of a person's gender identity or a characteristic that appertains or is generally imputed to persons who have that gender identity. Indirect gender identity discrimination is the imposition or proposed imposition of a condition, requirement, or practice that has or is likely to have the effect of disadvantaging a person relative to another person or persons who have a different gender identity. In about February 2021, Ms. Tickle downloaded the Giggle app and registered for an account. The account registration involved supplying a photograph of herself, which was scanned by artificial intelligence software designed to detect whether a person was male, and if so, refuse them access to the Giggle app. The scan software granted Ms. Tickle access to the app. Later, in about September or October 2021, Ms. Tickle realised that her account had been restricted. I find largely on evidence provided by Ms. Grover that restriction was likely to have occurred. Ms. Grover reviewed Ms. Tickle's photograph, considered her to be male, and removed her from the Giggle app. Ms. Tickle then contacted the respondent, stating that her access to the app features had been restricted. She received an initial email response from Ms. Grover, who said she'd look into the issue. Ms. Tickle followed up with an email but received no further response. Ms. Tickle attempted to call and text Ms. Grover using the number Ms. Grover had supplied in an earlier email. At that point, Ms. Grover called Ms. Tickle back, but the call was missed. There was no further contact from the respondents. Ms. Tickle did not regain access to the Giggle app. The substance of the respondents' defence is that discrimination did occur, but not prohibited discrimination. They claim that Ms. Tickle was discriminated on the basis of her sex, which they consider her to be male, not gender identity. They consider sex to mean the sex of the person at birth, and that is unchangeable. Those arguments failed because the view propounded by the respondents conflicted with a long history of cases decided by courts going back over 30 years. Those cases established that on its ordinary meaning, sex is changeable. The respondents' views also conflicted with clear parliamentary intention to prohibit discrimination on the ground of gender identity in certain contexts contained in amendments to the SDA that took effect over a decade ago in 2013. The respondents also claimed the Giggle app, as a female-only app, was a special measure to achieve equality between men and women, and therefore exempt from prohibitions on the discrimination contained in the SDA by the operation of Section 7D. I find that even if Giggle app could have been considered a special measure to adhere equality between men and women, that would not have allowed respondents to discriminate on the basis of gender identity, which is distinct from discrimination against women on the basis of sex under the SDA. The respondents' arguments, therefore, conflicted both with long-standing law as to how sex should be understood in the SDA and the gender identity provision of the SDA. In relation to the direct discrimination claim, the evidence did not establish that Ms. Tickle was excluded from the Giggle app by reason of her gender identity, although it remains possible that this was the real but unproven reason. A necessary part of proving that action has been taken by a person of gender. A necessary part of proving that action has been taken by reason of a person's gender identity, and therefore amounts to direct discrimination, is establishing that the alleged was aware of the person's gender identity. The evidence goes no further than establishing that Miss Tickle's exclusion was likely to have been a byproduct of excluding those who were perceived as being men by use of visual criteria that failed to distinguish between cisgender men and transgender women. The same evidence did, however, support the conclusion that indirect gender discrimination did occur. The indirect discrimination case has succeeded because Ms. Tickle was excluded from use of the app because she did not look sufficiently female, according to the respondents. This finding applies to the act of excluding Ms. Tickle from the Giggle app. It does not apply to her not being readmitted due to lack of evidence to explain this, or even to establish that any positive decision was made not to allow her reinstatement to the Giggle app. I was also required to consider questions going to constitutionality, validity of provisions in two statutes raised by the respondents. Whether Section 22 of the SDA, read with Section 5B, was beyond the scope of the Commonwealth legislative power to the extent that it prohibited gender identity discrimination, and B, whether Section 24 Birth, Deaths and Marriages Act 1994 Queensland was invalid for inconsistency with the SDA under Section 109 of the Constitution. This question refers to the provision that made it possible for Ms. Tickle to change her registered sex. As to the first constitutional question, I have found that Section 22 is supported by the Commonwealth's external affairs power as an enactment of Article 26 of the International Covenant on Civil and Political Rights. The relevant portion of the Article 26 provides that the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on the grounds of race, colour, sex, language, religion, political and other opinion, national or social origin, property, birth and other status. I've decided that gender identity comes within other status in Article 26. It follows that Section 22 of the SDA, read with Section B, is valid in its application to Ms. Tickle's case. The same result is reached in this case by finding those provisions are also an exercise of the Commonwealth Corporations power. This is because I find Giggle to be a trading corporation and Miss Grover to be its officer. One thing that is very interesting here, he said he decided that gender identity came in other statuses, but up here he said that according to that, sex was also changeable. So why, I wonder why he didn't put it under sex. He put it under other status. Other status. I'm sure that that is something that I'm interested in. Because if what he said earlier was sex was interchangeable, and now he's saying that under this other thing that it's an other status. It's going to be very interesting. Sally Grover, and Giggle for Girls are actually going to go to the High Court for this. And I guess this will be what they'll be arguing over. So, all right, so let's go on. However, I was not satisfied that the kind of gender identity discrimination alleged by Ms. Tickle under Section 22 would be supported as an enactment of the Convention for the Elimination of All Forms of Discrimination Against Women, 1979 CEDAW. The respondents contended that this was because the CEDAW grants protections only to women, and the word women in the CEDAW only means adults who are female sex at birth. I do not need to decide whether this is correct or not, because the way in which the term discrimination against women is defined in the CEDAW means it refers only to discrimination that places women in a less favourable position than men. It therefore does not cover the kind of discrimination that Ms. Tickle alleges in this case, which is discrimination that placed her in the same position as men. It is well established that questions of constitutional validity should ordinarily be determined if they are properly arise in the case. They have been brought in Liberty Works versus Commonwealth. Accordingly, it was not necessary to decide whether the term woman in the CEDAW includes transgender woman. So this, again, is a very interesting point. He actually has not made a decision as to what defines a woman, which is what people thought that this was going to be done. Now, whether he needed to do it or not, I guess, again, it will be a contention in the High Court decision, but he said he did not feel that he needed to do it. As to the second constitutional question, I found that there's no inconsistency between births and marriages in Queensland and the SDA. The two statutes can do and operate harmlessly. It follows both respondents' constitutional challenges failed. I found that Ms. Tickle's claim of indirect gender discrimination fails, but her claim of indirect gender identity discrimination succeeds. I made a declaration of the contravention by way of unlawful indirect gender identity discrimination against by the respondents, subject to input from both parties as to the form of that declaration. I'll also order the respondents to pay Ms. Tickle compensation in the sum of $10,000 and pay her costs with a cap in respect to costs to do with the constitutional validity and the statutory construction issues. So that was the short version. We get to the long version, and it is huge. So let's get to that. So a lot of it is actually already in here. So I will put the link in here so that you can read it. So here is a lot more. So this is the federal. So it was a human rights issue, constitutional law. When we get down to damages, that's what's really interesting. This is all the cases that he's quoted. So the judges make, this is legislation, then we've got all the cases cited. There's a lot that goes into it. That's why they take a lot of time, and they generally do take their time because they know also that they're likely to want to appeal. So we have, comes from the divisions from the New South Wales Registry. This is what it comes under. There's 283 paragraphs. This was the day of the hearing. This is the counsel for the applicant, the solicitor. So this is your normal lawyer, okay? And these are your barristers here. And then the intervener, Human Rights Commissioner, Commission also was there as well. So then we've got the applicant, the respondents, and so the order. So it says the parties confer and within 7 days provide to the Chamber of Justice Bromwich an agreed draft or competing drafts of a declaration of the contravention by way of indirect gender discrimination, that the first and second respondent pays the applicant the sum of $10,000 within 60 days, that the respondents pay the applicant's costs. The component of costs is awarded by Order 3, which relate to constitutional validity and statutory constitution issues, be capped at $50,000, being that the cap imposed in respect of those issues. Made on the 1st of June 2023, and entries dealt with. So, and then here we have a summary, so you can go. So you got the overview of the case and the pleadings. His interpretation of the key provisions. So this is about the history, the evidence that was given, the background evidence, expert evidence, whether he accepted some expert evidence he didn't accept, lay evidence, then he talked about constitutional issues, and then remedies, and then agreed value here, and then conduct at trial, agreed an apology and reinstatement. So this is how. So we start with the, and this is the summary. So the summary essentially gives you everything, like as to what's going to do the basic things. So this is the reasons here. Yeah. So he ignored the I guess it made. So this is how we got there. The key provisions. So here. So he said section 4 of the Sexual Discrimination Act. Gender identity means gender-related identity, appearance, or mannerisms, or gender-related characteristics of a person, whether by way of medical intervention or not, with or without regard to a person's designated sex at birth. And then discrimination, here it is about the discrimination of gender identity, Section 5B. For the purposes of the Act, the person discriminates against another on the grounds of agreed person's gender identity if by reasons of A, the aggrieved person's gender identity or a characteristic that appertains generally to a person who have the same gender identity as the aggrieved person, or a characteristic that is generally imputed to persons who have the same gender identity as the aggrieved person. The discriminator treats the aggrieved person less favourably than, in the circumstances that are the same or are not materially different, the discriminator treats or would treat a person who has a different gender identity. For purposes of this Act, the discriminator discriminates against another person on the ground of the aggrieved person's gender identity if the discriminator imposes or proposes to impose a condition, requirement, or practice that has or likely to have the effect of disadvantaging persons of the same gender identity of the aggrieved persons. The subject has the same effect of Section 7B and 7D. So that is 5B. So then we get to Section 7D. So it goes through here. 7B provides a reasonableness in relation to conduct. So conduct will not be discriminatory if the condition, requirement, or practice is reasonable in circumstances, considering the matters set out in 7B. The nature and extent of the disadvantage resulting from the imposition or proposed imposition of the condition, requirement, or practice, and the feasibility of overcoming or mitigating the disadvantage, and whether the disadvantage is proportionate to the result sought by the person who imposes or proposes to impose the condition, requirement, or practice. 7D allows a person to take special measures. A person may take special measures for the purpose of achieving substantial equality between a man and a woman, people who have different sexual orientations, people who have different gender identities, people who have, so they're all listed there, people without family responsibilities. The respondent's pleaded defence does not rely on Section 7B. So we go back here. And we've got the pleadings, goes through that, and their arguments, because, you know, a history of the amendments. So as noted, Section 4 used to contain a number of definitions that were repealed with the introduction of the gender identity discrimination provisions, including the removal of the following definitions of the words man and woman. Man meaning a member of the male sex irrespective of age, and woman meaning a member of the female sex irrespective of age. The word sex was and remains undefined in the Sexual Discrimination Act. That's interesting, isn't it? That's actually undefined. So they've removed man and woman, those definitions. Then there's an argument between biology and that. So this again is fact. This is evidence of factual conclusions. So that Ms. Tickle is legally recognised as a woman. She was male sex at birth, and in 2017 began to live as a woman. Transitioned using the name Roxy Tickle. Began testosterone blockers, estrogen and progesterone, including of inducing a second puberty and changing most of her body. She began to use female changing rooms, started playing local women's hockey team, began shopping from the women's side of the store. 2018, changed her birth certificate. 2019, underwent gender affirming surgery with a laboplasty and vaginal, whatever those words are. In 2020, she was reissued a birth certificate with now the female sex marker. So she downloaded and registered with the Google app in 2021. And then we got about Miss Grover here, about the CEO, and then we've got information on the app here. Here is how the removal of the app. Now here, Miss Tickle's evidence in the months after setting up an account is that she periodically opened the Giggle app, read posts in the Giggle talk section. She set up a profile, joined a few different forums. However, she found that there were not many users to connect and lost interest. This is important contemporaneous evidence because of its inherently greater reliability as to Miss Tickle's true attitude towards being able to use the Giggle app when it comes to damages and assessments, because it is relevant to the real measure of detriment suffered by being deprived of access to the app. This is important. She found that there were not many users and lost interest. Evidence that she reviewed Miss Tickle's profile after the AHRC complaint was made and found Miss Tickle had no interactions or connections with any other Giggle app users and had made no connections, no posts or other contributions. There was no cost examination in this evidence. The evidence from Miss Tickle to the contrary. So I accept that this is what in fact occurred. So she didn't like it. And I think this is very, very important. So he talks about the indirect discrimination. So she hadn't really been using the app, and then when she discovered she was blocked. That's when she took action. So then I then look at motives behind it all. And then, so we've got trading power corporations. This is all about the Giggle business stuff. So the remedies, Miss Tickle sought the following relief declarations that respondents contravened Section 22 of the SDA, 100,000 in damages, 100,000 aggrieved damages, a public written apology, and an order that Giggle reinstate Miss Tickle's access to the Giggle app. So he and she got 10, and I mean, I guess it is a bit because it was 10 grand. So the court does not grant applicants an unfettered right to litigate. Rather, the unlawful discrimination alleged must meet the requirements. So it talks about that. Miss Tickle relied on public comments made by Miss Grover about her. So declaration, it can make a binding declaration of unlawful discrimination. The respondents made no submission that a declaration should not be made if unlawful discrimination was still taking place. In light of finding that indirect gender identity discrimination has taken place, I'm satisfied that the declaration to that effect should be made. The respondents did not suggest otherwise, although it is not altogether easy to be sure, given the disjointed and somewhat incoherent way their case was run. However, the form of the declaration should be confined to discriminatory conduct as alleged, not the definition and other provisions referred to in the originating application. The contravention was indirect gender identity discrimination by halting Miss Tickle's access to the Giggle app and therefore engaging in conduct prescribed by Section 22 as described in the Section 5B2 of the SDA, subject to the parties providing joint and separate draft proposed terms for declaration. I will make a declaration of contravention. The purpose, and then talking about general damages. The loss was not properly quantified or otherwise explained by Miss Tickle, and the figures advanced by respondents in accordance with their view, that the court concluded that they had not done anything that was really kind of warranted more than a nominal response. He didn't accept either. He didn't accept the unquantified amount. So Ms. Tickle has adduced no observational, medical or other expert evidence to quantify loss or damage. and he's relied about, there's 3 paragraphs in here. The whole evidence for loss or damage because of unlawful discrimination is contained in paragraph 38 and 41. Paragraph 39 pertains to Ms. Tickle's claim for aggravated damages on the basis of comments made by Ms. Grove and her supporters, subject to the filing of this application. The loss or damage alleged fall into 2 broad categories: injured feelings, described in 38, and exacerbation of pre-existing psychiatric conditions in 41, and he's going to address it separately. There's no evidence of loss or damage in any monetary sums or in non-monetary sum giving rise to a reasonable basis for equating or approximating to the quantum. However, at 100,000 proposed was arrived at was not explained. In my view, such a large sum in the circumstances of this case called for detailed submissions. In the absence of such submissions, I'm not satisfied that anything approaching that sum has even been attempted to be justified. So he talks about this and injured feelings. So in the final part of Ms. Tickle's affidavit, she says that she wishes to halt the use of anti-anxiety medication, but fears that panic attacks will return to the stress caused by Ms. Grover's actions. Again, the reference to Ms. Grover's actions must be read as a reference to both the removal of Ms. Tickle from the Giggle app and Ms. Grover's subsequent comments, the latter of which cannot ground an award of damages. It is similarly unclear whether the stress and anxiety that Ms. Tickle has experienced from this proceeding refers to the actions taken by the respondents in the course of the proceeding, and if so, which were more from the general stress attached to any legal proceeding. The latter cannot be grounds of aggravated damages. More fundamentally, however, this is the only evidence of her speculation as to future effect of halting the use of anti-anxiety medication while experiencing stress and anxiety. It is not a loss or damage that has eventuated. Ms. Tickle is not a doctor or otherwise an expert on the matter, and accordingly, I cannot give self-assessment any weight. And then he talks about injured feelings. Despite the conclusion, the emotional effects of her gender identity being denied to have some significance, she says that this has greatly upset her. However, I'm unable to attribute responsibility to the respondents for her finding this, in her words, exhausting and draining, and to have to go to great lengths to prove that she is a woman. Overall, Ms. Tickle's evidence as to loss or damage is slight, if not minimal. It does not rise higher than a modest degree of hurt feelings. Taking all of these considerations into account, I find a sufficient basis has been established to make an order for modest award of compensatory damages. So now he's talking through his thing, and so this is where the $10,000 comes from. He says, the features of the conduct that took place have been considered in some detail for these reasons. I am left with an exercise akin to a penalty or a fine imposition of an indistinctive synthesis in which there is no single right or wrong figure. There being nothing precise such as proven economic loss, I consider the amount suggested by the respondents to be far too low and the figures suggested by Ms. Tickle to be too high. After some considerable thought and reflection, I've arrived at the figure of $10,000 in damages. As I note below, there is one limited basis upon which Ms. Tickle's aggravated damages succeeds, but where harm caused is relatively slight and difficult to quantify. The damages also reflects that limited aspect of aggravated damages. The award of $10,000 is more than a nominal sum, but remains modest to reflect the reality of what has taken place. The limited evidence Ms. Tickle chose to adduce and the narrow ambit of harm that has been shown to have been caused. Given the novelty of this claim, I should note the quantum does not reflect the potential seriousness of gender identity discrimination that might emerge in another case. This kind of discrimination is just as capable of being harmful as all other kinds of discrimination listed in the SDA, and therefore justifying substantial awards of damages. The quantum in this case reflects the case that was proven. At the proven facts differed or the case focused or run differently, it is possible a much higher quantum had been justified. Let's talk about aggravated damages. Now, because there was a And so here is this for aggravated damages. You have to show that a compelling evidentiary basis for attributing the conduct said to give rise to the claim for aggravated damages to either or both respondents, a clear nexus between the conduct and this proceeding, which in turn to be tethered to the complaint to their AHRC, which gives rise to court jurisdiction, and clear evidence of separate or additional harm caused by the conduct. Now he says that none of the three criteria are met, and any one of which failure would be fatal to the claim of aggravated damages. Moreover, as detailed below, the veracity of the evidence chosen to be advanced by Ms. Tickle ended up making this proceeding a poor vehicle to question the outer bounds of the court's power to award damages for subsequent conduct. So he talks about that. No relevant part of Ms. Tickle's affidavit reproduced at 217 above, and which is the only evidence of loss or damages suffered by her, makes any reference to the harm caused by the respondent's refusal to attend the AHRC conciliation proceedings. Proof of the necessary nexus has not been attempted. There is no apparent basis on the evidence from which I can reasonably infer that the refusal caused any loss or damage. Ms. Tickle does not suggest in her evidence that such a basis exists. So then, in the alternative, the applicant submits that the refusal to reinstate Ms. Tickle's access after she filed the complaint grounds a claim of aggravated damages. However, no part of Ms. Tickle's affidavit, being the only evidence of loss or damage, mentions that as a loss or basis for a loss or damage she suffered. There is no factual basis for finding this evidence. And then, unlike grounds A and B, Ms. Tickle does refer to comments made. So she does refer to comments made. And so she probably makes that ground. These comments, however, while hurtful and perhaps even defamatory of Ms. Tickle to a limited degree, lacked a sufficient nexus with an unlawful discrimination found. They were in nature an attack of Ms. Tickle's character rather than arising from or as an extension of the indirect discrimination. Then he talks about conduct at trial. Apparently Miss Grover, he wasn't very impressed that Miss Grover laughed. His conclusion for the aggravated damages. So he talks about the fact apology. The applicant's case for an apology to be ordered was sparse, to say the least. It is plain that any apology given by Miss Grover and any apology given to her on behalf of Giggle would be through clenched teeth and utterly devoid of sincerity. Should be doing no more than saying that she was sorry, but she would not be in fact sorry at all. She adheres to her sincerely held beliefs. It is not appropriate to order the giving of an apology in those circumstances. Then another one was wanted reinstatement into the app. The app has been shut down, and Ms. Grover has expressed a clear intention not to reinstate it unless it is legal to exclude transgender women. Accordingly, at present, Ms. Tickle already has the same access as other female users, being none at all. If the Giggle app had been in operation, I could well have ordered its reinstatement. However, in the circumstances, it's not appropriate to make an order because it can't be complied with. So although the applicant did not include seeking costs in their pleading, costs were argued at the interlocutory hearing last year. It was plainly both in contemplation. So as I said, I will order the respondents pay costs of up to $50,000. So that was the order. So as I said, the interesting part of that was the fact that there was no interaction on the app. She wasn't interacting. She wasn't talking to people. She wasn't meeting people. She was just on the app. And that I think that didn't help. And if there was no interaction on the app and she wasn't talking to people, so it's like you've looked at something, you could access something one day and then you couldn't access it the next. So that's when she got upset. So anyway, that's where we stand. I'm going to put the links in. Feel free to have a read of it if you want to. Very interesting when you get into the crux of it. Sally Grover, as I said, has said that she will appeal to the High Court. So it's going to be interesting to see where this goes. So at the moment, there's been no definition as to what defines a woman. But I know this is being watched. This was very, very. So everything didn't go the way of everybody. It could have been a lot worse for Giggle and Giggle for girls. I think, to get 10,000, so essentially possibly $60,000 is, one of the things that did interest me was the statement where Miss Tickle said that she can now get on with her life, and she's been, 3 years to her life. She brought the action. You've got to remember, if you bring the action, there's a consequence to that. It's going to be stressful. So anyway, that's where we are at the moment, and I will catch you again next time. Bye for now.